Hi, I'm Ed Ricci, and I'm a partner at Searcy Denny Scroll at Barnhart and Shipley. We're going to be talking about Florida's wrongful death statute and how to prove damages under that statute. So what is the wrongful death statute? Well, it's a law that the Florida legislature passed that sets forth the requirements and what can be recovered when someone is killed by the negligence of another. As far as who can make a recovery when someone is killed by the negligence of another person, or how much can be recovered, or what types of things can be recovered, that's something that was decided by the legislature. And a lot of times we find that clients are surprised about what was included and what was excluded as far as that law is concerned. So let me give you an example. Children under the statute can recover for the loss or for the death of a parent, but the Florida legislature has decided that children are persons under the age of 25. So if someone's parent is killed and it's a week before that person's 25th birthday, then that person would be allowed to make a claim. However, if the death were to occur a week later, that person would be excluded. Let me give you another example. If a doctor were to run over a patient in the parking lot of a hospital and kill the patient, the adult children of the patient would be allowed to bring a claim against the doctor for wrongful death, assuming there is no surviving spouse. Now, assume the same doctor, same patient, same hospital. If the doctor were to commit malpractice and kill that same patient, well, those adult children would not be permitted to make a claim for wrongful death against the doctor, because the legislature has decided that doctors, while practicing medicine, get special protections that the rest of the public don't get. A lot of people ask themselves, well, what's the difference between a 25-year-old or a 24-year-old and, let's say, a 40-year-old who loses a parent? Now, certainly each person's loss is going to be different, but it seems patently unfair that someone who could have a great loving relationship with their parents when they're in their 40s and who loses a loved one isn't permitted to recover, whereas someone under the age of 25 is allowed to. But the legislature has decided that that's the way it's going to be, and they've drawn a bright line rule, and unfortunately for those over the age of 25, it doesn't work in their favor. When someone loses a loved one, there are certain damages that they're allowed to recover according to the law. There are two basic categories of damages that one can recover in a wrongful death case. The first would be economic damages, and those are things like medical expenses, funeral expenses, lost earnings in the future, that type of thing. And then the other would be non-economic, or what we refer to as human damages, and that has more to do with the relationship between the person who is deceased and their loved ones that were left behind. Jurors can have a more difficult time understanding and calculating and deciding what human damages are for any particular person, because it's such a particularized analysis, meaning that every person's loss is different, and so it's harder for jurors to understand. They have to really be able to stand in the shoes of the person who has lost a loved one in order to really understand the magnitude of their loss. Oftentimes, jurors who are sitting and hearing the case are not going to be people who have lost a loved one due to negligence. Under the circumstances, it's frequently you will see that if jurors have an experience that is similar to what our clients have experienced, they often will be prevented from sitting on the jury. So we're dealing with a group of people who may find it difficult to put themselves in the circumstances of our clients, because a lot of times they don't want to believe that something like this could ever happen to them.